дозвольте мені розпочати нашу сесію.
Our session is a really interesting session as well as all other. So we'll talk about enhancement of investigative power and cooperation with law enforcement authorities to ensure effective investigations of cartel and similar offenses. It's very important topic for any state, including Ukraine. There are many developments. There is certain toolkit available to the Anti-Monopoly Committee and provided by the Ukrainian legislation, but we have wonderful opportunity to listen to the experience of other countries. We have here representatives of jurisdictions where cartel entails criminal liability. There are jurisdictions where no criminal liability would be entailed. We'd like to hear about delimitations between the powers of law enforcement and anti-monopoly agencies for purposes of conducting inspections or investigations also we'd like to talk about the amnesty many countries provide for such a tool. Ukrainian legislation has it also. I think we'll discuss that separately. We'd like to understand how effective this tool is in other jurisdictions and whether criminal liability is related to effectiveness of this tool. And I'd like to introduce to you my co-moderator, Stefan Lucy from Canadian Bureau for Competition. I hope he'll also, based on his experience, will actually present the conclusions in the OECD report. Thank you, and thank you for staying here in Friday afternoon. I know it's not easy. I'm not going to tell you about what and how we do it in Canada, because my colleague from the US will now tell about how it's done in the United States. Actually, we learned from them and we used many of their tools. So she will explain better how it all works. I would like just to draw your attention to several points that were tackled with in our OECD review. Let me read from this review. I think Frangini and others already explained why you need strong tools in this area to support this area of the law. So I'll tell you what our findings were, and now
Антимонопольний комітет має цікаві сили. The Anti-Monopoly Committee does have the authority to request information in writing and to conduct unscheduled inspections for business. However, it's a цікава різниця. This is an important distinction. The Anti-Monopoly Committee cannot search and seize for documents without the consent of the undertakings under investigations. Тобто без дозволу не може брати документи. Такого тяжко повірити в цій дільниці, сказати вам щиро. Unless this investigator possesses a warrant signed by the commissioner that specifically identifies the document to be seized. Тобто я мушу сказати, як нам пояснювали це.
Well, when we arrived here, they explained it to us that it was really a disappointing statement for us. Somebody shows up for inspection, and how come they would know what kind of documents they're looking for? I really apologize. I'm switching from English to Ukrainian, so that's why I'm trying to. Okay, it will just wake you up, maybe.
Similarly, while the Anti-Monopoly Committee has the authority to invite employees and other individuals to interviews. The individual cannot be questioned unless he or she consents. Тут треба попросити
До опитування і при цьому вони мають право на, well, again, they explained it to us, we couldn't believe it. For those who work with criminal proceedings, it's kind of really surprising system.
The Anti-Monopoly Committee і ця група, що працює в цій ділянці для комітету, мушу сказати, вони є дуже бистрі і сильно працюють в цій ділянці. They have developed ways to get around these problems. For dawn raids, a commissioner attends the inspection of the business premises and can sign a warrant on the spot. Тобто
У разі виявлення необхідного предмету виписує відповідно одноразовий ордер. Also they have the authority накладати штрафи в разі, якщо підприємство чинить
refuse to cooperate. І то може бути
перевірки, and that may be 1% від доходу.
The Anti-Monopoly Committee can request the employee's manager to instruct the employee to attend the interview. And the AMC can fine undertakings which employees refuse to be interviewed for obstructing investigations. Тепер,
В цьому разі знов-таки
is marginally improve the Anti-Monopolies Committee's ability to conduct dawn raids and investigations. There still are problems. With regards to the fine, то щодо
все одно існують проблеми, які стосуються штрафів. If somebody has to pay this choice, whether they pay 1% or pay the penalty, you can easily guess what their choice would be. And another aspect concerning interviewing, what they told us when the IMC requested the interviews, such interviews, the people were getting sick or just would take a vacation, so those people were not there.
The new ways that were being developed to enforce these rules. Останню річ
One more point that I'm going to make concerning recommendations. You can read it, of course, but what we're saying is that we recommend to correct this problem. Without that, the AMC would not be able to do its work in the area. Also, what we heard was that the Parliament directed the IMC in the year 2014 and 15. Actually, the committee was recommended not to send out any inspections, so that they not interfere with the free economic development of businesses and of the country. So those people who were who had this task actually still couldn't do anything because they were not allowed by the parliament. I understand the reasons behind that, but of course, certainly that didn't help at all to the activities of AMC. These were the findings of our review. I'm not going to waste any more of your time. Now you will hear from other panelists about the ways how these things are processed and worked on in their jurisdictions. Thank you very much. We'll get back to these issues. So the moratorium for inspections is still in place until 2017. Let me get back to our speakers. The first speaker will be Bogdan Kyrytoi, Chairman of the Council for Competition.
Yeah, thank you very much. First of all, it's a great pleasure to be here again. Even if, okay, I'm speaking after lunch and on a topic which is not my normal topic. I'm very much a policy guy. This time I have to talk about the fun part of the job, this police type of work, how to get a company, how you rate them. As I said, it's not my my first inclination, but if you want to do policy, if you want people to take care of you, you need some big scalps. So normally, big fines concentrate the attention, So since we are joined by the Americans, I like the American expression, speak softly and carry a big stick. So you need a big stick. And I think this was said before yesterday. I have a presentation prepared at home, 12 slides, so it's a bit long. It covers two parts. One, some general things about how we are organized, which is almost the same like everybody else in Europe, even if I realize that some of the things are missing here, but it's relatively similar with everybody else. Then a few slides about the new things that we're doing, some of which you are doing already, like interviews. And then I thought I'll have, if I have time, to have some comments, some reactions to things that have been said in other panels. So I'll try to skip very quickly through a few things about the council. Okay, it's a unitary model, as you are, and as almost everybody now in Europe is a unitary model. We're a bit different. We're a bit organized closer to the Commission, actually, not like member states, because we are not organized on practices. We still have industrial sectors, so divisions which are specialized in industrial sectors. But for cartels, it's a special unit, and tenders are also a special unit. The law is pretty similar with the treaty, EU treaty, I mean. Okay, we can open complaints or ex officio. We do prioritization, but prioritization, to be honest, we never declined to open a case because it was not a priority case. So in theory, we could do it. We've never thought we have that many cases that we should stop opening new cases. But we allocate resources depending on priorities. If it's considered a big case, then it's going to get more stuff and better stuff. So in this sense, priorities or prioritization works. Like everybody, we could ask him for information from companies. We can force them to provide information. It's a pretty big fine if they lie to us, or if they do not provide information. If they block an inspection, we could give them 1% of total turnover. For large companies, this could be millions of euros. So we do not have this issue with companies not allowing us in or things like this, It might happen with some smaller companies who do not know the law, somewhere outside Bucharest, But if you go to the big companies, to the big multinationals, they know the law, and the lawyers advise them to comply with us, So we don't really have this issue. We can use information from other authorities, and we provide information to other authorities, and I'll go back to this issue. Dawn raids, traditionally we're photocopying things we're finding in companies. Now more and more we rely on forensics, so we copy the hardware of the computers and we take the copy in our offices, and that's where the analysis is done. Legally it's a gray area in some parts, and we have to be a bit creative, So smartphones, not theoretically, we go with a judge warrant, and this covers the premises of the company. Theoretically, that could be an issue if you go to laptops or smartphones. People could claim there's private information there. Well, in reality, it has never happened, So when we tried to copy things from smartphones, nobody objected. So it worked, We'll see. When lawyers get cleverer, we'll see what happens. Forensic takes a very long time. We are allocating more and more resources. We have 3 labs. Now this year we'll buy the 4th one, because maybe we don't know to do the searches narrowly enough, but it takes a very long time to do search. If you copy huge amounts of data and you look for keywords there, may take a very long time, And of course we're harassed by the lawyers who want to be present during the whole process. Interviews in a new thing, Legally, nobody's stopping us to the interviews. It's just that we don't have the skills. We're not policemen. Yeah, as I said, that's a type of police work. Yeah? So we're used to send letters and get back information, and our main instrument is the dawn raid. Yeah. So interviews was not something we're accustomed to. Okay, last year we formally introduced it in the law, and we trained 24 people in interview techniques. We'll see. They're voluntary, but so we cannot force people like you. We cannot force people to take part in interviews, but if they come voluntarily, they are not allowed to lie to us. So, okay, they may decide not to come, but if they come, they have to tell the truth. Otherwise, we could fine them. Now I switch a bit to tenders. So we try to develop cooperation with the huge number of public institutions involved in tenders. We're the only one who deals with companies. Yeah, all the others deal with public administration. Yeah, so the focus of the Romanian government is that we suspect our staff to be dishonest. Yeah, and all the efforts it's on corruption. Yeah, well, the only ones who say, okay, maybe also the companies are crooks. Yeah, not just the civil servants. So we try to two things: to get information from these institutions, and in order to get information to tell them what kind of signs might show there is collusion between the companies participating in tender. We're using the OECD toolkit for this. And here there are some cases you could see in different institutions that send us suggestions, not fully complaints, but things that look suspicious to them, and some of them resulted in investigation, some of them not. So obviously people don't know always very well what to send us. On the other hand, I don't want to discourage them. I think it's better that they send garbage, and sometimes we find something good in it, rather than them restraining themselves and not sending us information. And a number of cases, a few cases and fines. A new thing, it's, I'll just go back a second. You see, some of them come from the prosecutor office, so this Directorate for Investigation Organized Crime. We also, and some from some complaints have come from the anti-corruption prosecutors. We also send them cases, so try to make it two-way in order to gain their trust and to see that we are also valuable partners. And we sent to the prosecutor, we sent two complaints last year, for example. We'll see if they resulted in convictions or not, but we're trying to make it a two-way street. Whistleblower platform is a relatively new development because leniency is not doing that well, as well told yesterday. It's apart from Western Europe, leniency is not very successful. We thought that we could use the old communist skills of people telling on their employers, friends, relatives, or whatever. So we get a lot. This is an anonymous, so people who want to stay anonymous, they could. No reward. This was blocked by the parliament. If you know the Hungarian case, the Hungarians can provide rewards too. In Romania, again, the parliament thought it's too close to the communist secret police, to reward your informants. So this was denied, and we haven't pushed it. Maybe if we see that it's working well, maybe we'll go there and ask for rewards. But for the moment, we're trying it as it is. Last year, we opened one important case based on that. Most of the things, again, are garbage, are general complaints about life sucks and things that we cannot deal with. But sometimes you get actionable intelligence, and we opened a case against the tour operator, the tourist companies, which looks a promising case. What works very well is settlement. So leniency is getting there. I think we got last year 4 leniency application, which for us it's good. Much more than used to be. It used to be none or one. Now 4 in a year looked very good last year. Settlement, is doing very well. We improved the law last year, so now companies could come. We want companies to come early for the settlement. Yeah, we don't want them to come only at the end of the case after we work 2 or 3 years. So we'd like them to come early on. We give them very good discounts in the fine, so we're very generous. I call it a promotion campaign for the settlements. Gradually we'll get less generous if we see it works, and it worked. We have, I think, last year 90% of companies sanctioned settled. Yeah, so we sanctioned 100 something companies, 90 companies settled. Okay, normally it's small companies, probably they don't have a lot of capacity, they don't want to hire lawyers and so on. They're a bit afraid of us because we have a very good record, and this was one point I wanted to say. You have to be credible. We have a very good record in the courts. We haven't lost a court in 2 years in the High Court. They reduced the fine on average by 20%, but we'd never have lost a case in 2 years. We'll see how long the luck lasts, because we lost some nice cases in the lower court. Yes, okay. In the next couple of years, they will get to the High Court. We'll see if we can overturn the lower court in the High Court. But yeah, I'm not a lawyer. I don't really understand what they're doing, but they must be doing something right because we keep winning. Yeah. Okay, settlement. I think it's a success. It's a bit risky. It's basic. It's very close to bargaining, and that's a bit because what we introduced in the law, nobody is going to settle if they don't know how much money they are going to pay. So they come to us, they say, we want to settle, and they say, yeah, and the fine, we think we should calculate the fine like this, and they say, yeah, but could we have a mitigating circumstance that? So eventually we got to a percentage of turnover, which means an amount of money, and that's when they settle. So we have to be, developing internal procedures, because I don't want to be accused, or the staff to be accused, that we gave sweetheart deals to one company or another. Yeah? So we're introducing a lot of checks. A lot of people have to be present there, the meetings have to be minuted. Sanctions have to comply with our normal sanctioning policy. So we introduce a lot of these quality checks inside the organization to make sure that we take good decisions, and to make sure that we can prove to prosecutors that we reached a good decision, if ever they will come to ask us. Hasn't happened yet, but as things look like in Romania, it's a question of time till you get this. Last year prosecutors came to ask about a decision in 2004. Yeah, director was retired, my predecessor, okay, he's out of the institution. Yeah, these people don't remember what they signed in 2004. Well, they have to answer questions, and so it's the law has a very long arm and long memory. What we try to do, it's a big data project. So we'll do two things, to look into open sources for cartels, and to have a filter in public procurement database. So I hope we'll get funding from the government on this. I guess this was the prepared comments. Just a few things to emphasize. You mentioned fraud. I don't know how it was not a major issue in Romania, or maybe it was and we did not realize. We normally fine multinationals. Multinationals are not going to be able to avoid a fine by, changing the name or something. Probably it happens with, or it might happen with some smaller Romanian-owned companies. And that's one of the things. Next time we change the law, we've been very successful lately in tweaking the law. Each year we find out there's a loophole somewhere, so we close it. Successive governments have been very, very friendly to us, and we've been able to make adjustments in the law as we wanted, which annoys the lawyers again, that we keep closing the loopholes. Okay, next time when we change the law, probably next year, That's one of the issues I'd like to look at, yeah, how to not to allow companies which are under investigation to change assets, shut down and reopen, things like this. I know the issue is on the agenda of the commissioner also. Commissioner Vestager is thinking about, so apparently it's happening on a larger scale in Europe, where we also have problems, and here maybe we need EU help, is getting the money from companies which are not located in Romania. So we had difficulties. We do not cash the money ourselves. It's our tax authorities. There are no problems in collecting the fines. Where we had problems has been with companies which have businesses in Romania but are not physically located in Romania. We had problems with Greek or Swiss companies, yeah, where our tax authorities were not able to collect the fines. So that's another issue which we should look into it, but it's relatively seldom when you have this situation. We used to go with down rates. I keep jumping from one topic to another. We used to go like you for down rates on my signature. 3 years ago, the Parliament introduced the judge warrant. We've been very scared about this. We thought maybe it's going to slow things down and whatever. It didn't. We didn't have any warrant refused. It takes something like 1 week to get it. So it delays the dawn rate by 1 week. But I don't think it was really a hinder for us. And I think I'll stop here. If there's other questions, we could go into the work with regulators, things like they've been addressed in the previous panel. Yeah. Okay, thank you very much.
З нашими регуляторами, про які йшлося перед тим. Thank you very much for a very informative presentation in which you covered the Romanian and partially EU experience. It would be now good if we could hear about US experience from Donald Shepard, DO.
Hello, everyone. My name is Alex Shepard. I'm a lawyer for the U.S. Department of Justice in San Francisco, and I was not offended at all of the lawyer jokes because I'm used to them.
Private lawyers, not the government lawyers. Government lawyers
Okay.
are good.
Now, you've already heard this from my two colleagues from the United States today, which is that when I'm speaking today, these are my personal views and not necessarily the views of the United States Department of Justice. I wanted to tell you first that I'm actually here in the Ukraine for 4 months, not just for a couple of days. I'm working as part of a USAID project as a technical advisor with my colleague Brian Telpner, who spoke this morning. We physically sit at the AMCU, and we are working with the AMCU, with local civil society organizations, with the CDF on competition issues in Ukraine. So this has given me an opportunity to see firsthand some of the challenges that were described in the OECD peer review, and also over the last day or so in this forum, and specifically on some of the significant limits of what the AMCU can do. I think Stefan yesterday used the analogy of, at least in cartel cases, that the AMCU is boxing with one hand tied behind their back, and I think that's right. I'm a cartel lawyer, and that's what I'm going to focus on. Most of you probably know this by now, but in the United States, cartel offenses are criminal. And when we talk about big sticks, that's a pretty big stick. What it means in practice is that it is a crime in the United States to fix prices or rig bids or allocate markets. Also, individuals can be held criminally liable in the United States for these same offenses, and this is really important. This means that individuals can not only be fined, but can also go to jail for their participation. And of course, corporations can be fined. We use there's guidelines for this, and so these fines are things that are predictable for companies. But the penalties can be very, very significant. It's up to $100 million US or more. And the or more is a very powerful tool that we can use to find companies under a specific set of circumstances. Individuals can be jailed for up to 10 years, and they can be fined up to $1 million US. So pretty significant penalties. The penalties are tied to the volume of affected commerce in a case. We can't just threaten to put someone in jail for 10 years, for example, for an offense that only caused a certain minimum amount of harm. Despite the difference in the liability scheme between the Ukraine and the United States, we face some similar challenges in our cartel enforcement in the US. Obviously, it's hard to find cartels in the first place. We have to be able to detect them. It's hard for us to gather sufficient evidence to prosecute cartels. And of course, there's evidence that's subject to a false but plausible, innocent explanation, and we need to find ways to deal with that. And finally, like every government agency everywhere, we have a lack of enforcement resources. I understand our limitations are not as severe as the AMCU's. But at the end of the day, enforcement agencies, we all have some similar challenges. In order to be successful in the United States, we have a variety of effective tools that we can use. And I want to talk about a couple of the ones that the OECD report focused on, because I think these are tools that can be implemented here in Ukraine. These are the big stick, in addition to criminal penalties, that you need in order to be able to prosecute cartel crimes. We have a variety of tools. I'll just walk quickly through them to give you a sense of what we can do, but I want to focus, as I said, on just a couple. We can execute search warrants, which are like inspections here in the Ukraine or dawn raids around the EU. We can talk to witnesses either voluntarily or we can compel them to speak to us. And those are the two things I want to focus on in my talk. We can also issue document requests, and because these are criminal cases, we actually can compel the responses. And there can be criminal sanctions for not responding. Typically, people respond, and the criminal sanctions, I think, are very limited, but still, we are able to compel those responses. We use undercover informants in some of our cases. We do audio and video recordings. And we also can do international assistance requests from our partners here in this room, for example. So as I mentioned, I want to focus on two things in particular that we do in the United States that are very effective and that I think are worth enhancing the powers of the AMCU to do here. If there's time, I can talk a little bit about our leniency program, but I think we all understand the challenges of leniency. It can only take you so far if there's no real penalty for actually not getting leniency. So search warrants. In the US, we use search warrants. This is our version of raids. This is a really important tool for gathering evidence. We don't use it in every case, and the reason is that we do have a series of procedural safeguards that I'll talk about. Another important feature of search warrants in the United States is that they can be executed at the premises of companies, but we can also go to individuals' homes. And that prevents individuals who are participating in conspiracies from hiding evidence. I mean, it doesn't prevent them, they do it all the time. But it prevents them from being able to keep it at their homes and keep it out of our hands forever. So we have significant safeguards, but in return for the safeguards, we have authority to search for and seize documents without permission. All we need to do is get permission from a judge. We do not need the entity or the individual's permission to enter their premises. And there's no limitation on how long we can spend getting the evidence, which I understand is a difficulty here in the EU, or I'm sorry, in Ukraine. What are the benefits? This is probably obvious to a lot of you who are involved in this. The element of surprise is critical. We do not have any obligation to inform entities when we open an investigation. We do a whole piece of our investigation in what we call a covert phase. That means nobody knows but us, and that's really, really important. So when we show up to do a search warrant, nobody knows that we've been out there investigating them, most of the time. The surprise enables us to seize more evidence. As soon as companies know about an investigation or individuals, they start destroying evidence. We know you've seen it here in Ukraine. We see it in the United States still. Search warrants mean that witnesses don't have time to get their stories straight. There's still going to be opportunities to do that, but generally speaking, it minimizes that chance. The company doesn't have time to coordinate with competitors on how it's going to respond to an investigation. Again, there are still going to be some companies and conspiracies that will do that, but it really minimizes the chance. And finally, as I mentioned, it minimizes the possibility of document destruction. In every single case I think I've ever worked on, there has been some sort of document destruction. It's always going to happen. But if you have the ability to go in without notice and seize evidence, then there's no chance for that to happen. Another benefit of the search warrant is it's your best access to unsanitized evidence. That means before lawyers get involved. And as much as there are always lawyer jokes, the truth is once you get lawyers involved in an investigation, evidence, they can't withhold evidence. Of course, lawyers have an ethical obligation, but it makes it a lot more complicated. Search warrants are the best chance to see certain types of evidence, electronic evidence, internal company records. We also are able to do witness interviews both on site during an inspection, and also we do them independent of the search warrant. We just show up at people's homes or their businesses to talk to them. I'll talk a little bit more about that. So I want to talk to you a little bit about the procedural safeguards, because that was a subject of discussion yesterday. And there was some concern that search warrants could be abused. And there's a reason why we have these safeguards in the United States. It's this concern about abuse. The warrant has to be approved by a judge. It's the same as it is in Romania. It requires, this is going to be a little bit technical, but a reasonable cause to believe that a crime was committed and that evidence of the crime is on the premises to be searched. In other words, that there were cartel meetings at that location, that there was business conducted at that location for the cartel, that somebody received a phone call there, or a fax, or emails, or we know there is evidence kept on site. Now that obviously means we have to have some evidence about the case before we can get a search warrant. And that's why it's helpful to have these additional tools. It's why it's helpful to have a really effective leniency program, because the leniency applicant is often the one who provides us enough information to get a search warrant. And I think it might be helpful to give you just a short example of the kind of evidence that we need to get a search warrant so you understand where the safeguard comes in. I did a drop-in interview on an individual. I went with an FBI agent to somebody's home. We often go at around 7 o'clock in the morning when people aren't awake or suspecting us. And their guard is usually down because it's early. We ask them if they're willing to talk to us. We tell them we want to talk about X industry, the pen industry, and we think they might have information to help us. And we ask if they'll talk to us. Frequently they say yes. In this case, we sat with an individual around 7 in the morning, and he was in his pajamas, and he talked to us about this industry. And he tried to spin a story about how it was very innocuous, and the meetings that he had with his competitors were simply joint ventures so that they could purchase properties together. This is all public information. During the course of the discussion, he pointed out some documents and just said, these are documents that relate to my business. Well, in this case, the information that he shared with us was enough for us to get a warrant to search the premises of his home, because we were able to say that there was evidence of discussions with competitors located at his home. And a judge agreed, and we were able to execute the search. If we didn't have that, we could not have searched his house. So that is a way that we are able to avoid abuse of this system, and that's important in the United States. Once we have the approval from the judge, the search is done by the FBI, not by us. They don't want us on site. We are lawyers. We often can only cause chaos. So the FBI will go, and they do something else that I think is really, really important that cannot be done here, which is they secure the premises completely. No work is typically done during the search to prevent destruction of evidence. It's really important. So the FBI will ask individuals to join them in a conference room, and they will secure computers and documents, and they will also get the assistance of company personnel to locate offices, computers of specific people, the things that they want to search. Nothing can happen on the premises while this is going on, because if things were allowed to happen, that's how evidence gets destroyed, that's how stories get created. And then the FBI essentially seizes the documents. They take them. We can take originals. They will make copies of electronic documents, and they'll take as long as they need. Sometimes this could go all night long, and there's nothing the company can do. When they're done for the day, when it's 5 o'clock, if they still are sitting in their conference room, they can go home, and the FBI will stay and continue the search warrant. There's something else that we can do, and the AMCU can do this as well, which is interview witnesses on site at searches. And in fact, in the United States, these are voluntary witness interviews. We cannot make them talk to us. And in fact, there's no penalties if they say no. So that's a significant difference. In some ways, I think you have more power here and up front. But obviously, when they do talk to us, and that's true here too, it's very useful. You can get useful information, but you can also commit people to lies. And in the United States, those lies can actually be prosecuted criminally because you're lying to a federal agent. And those lies can be useful if, for example, a company's lawyer calls us later and we're able to tell them that we can prove that a person lied to us. People don't want to go to jail, and so they tend to be more cooperative when they realize that they might have made a very significant mistake by lying to the FBI. But we also sometimes get really useful information. People won't always admit to crimes in these interviews, but they'll tell us about the company, the market, the co-conspirators, and then sometimes they actually talk about the conduct. They commit witnesses to testimony, which we can later hold against them if they change their story. We can educate witnesses and also the company about the strength of our evidence. We can use them to corroborate documents, to confirm documents, because it's so early in the investigation, they don't know. They might just say, yes, this is my document and I wrote it. And that for us is actually important for trial. As I mentioned, we use trained law enforcement agents to do all of this, to conduct these witness interviews, to do the searches and seizures. I have a lot of experience interviewing witnesses, but at the end of the day, on site, I think it's really important to have the FBI do this and not me. The FBI will take notes on the interview, and another significant difference, I think, between here and Ukraine is not only do we not have to show the notes to the company, and here I think it may not be required, but we don't. We will not share that report of the witness interview during a search warrant with the company unless and until the company is charged criminally and wants to take the case to trial. We have the discretion to share information from those interviews, but only when it helps us. When we can tell the company, your guy actually admitted something to us. And that's really, really important. It gives us an informational advantage, which is critical. I have some talking points about cooperating with, actually I'm going to stop and step back. I have a handwritten note here I can barely read. There's one other thing we can do with witnesses, and we can compel their testimony. Obviously, we can't do it in these search warrants or when we go to people's homes, but we have a grand jury process, which is the mechanism by which we conduct criminal investigations. We compel people to come talk to us, and if they don't, there are sanctions for that. So we can't force them, we can force them to talk, but we can't force them to incriminate themselves. And so we will typically call witnesses rather than potential defendants before the grand jury. And when somebody comes to talk before the grand jury, 9 times out of 10, we will likely give them immunity from prosecution. So again, we're focusing on witnesses, but we can essentially make them talk to us by immunizing them, and they have no choice. They're ordered to testify by the court, essentially. So cooperation with other law enforcement agencies, there's not a lot to say about that other than what I think we all recognize, which is that it's important, it's useful, that a team is greater than the sum of its parts. And we, I think like they do here, reach out to all sorts of agencies, not just the FBI, but also the securities regulator, the tax agency, our equivalents at the state level. It's really, really important. And I think in the interest of time, I'm going to stop. But of course, I'm happy to answer questions. And then if there's time and we want to talk about leniency, I could do that.
Я впевнена, дуже вам thank you very much for this wonderful presentation. Let's applaud. We will come back to many of the issues have already been raised. Я перейду на українську мову.
So I think we'll ask questions after we finish with the presentations. More constructive way. Now our next speaker is Ebro Inchi, representative of...
Так, давайте ми тоді трошки переформатуємо нашу дискусію.
Let's reformat our discussion. Let's first give the floor to the Chief of Legal Department of the Committee for Regulation of Natural Monopolies from Kazakhstan, Mr. Spanjandus Ibadullah. I apologize. Well, first of all, I'd like to thank the organizers for this invitation, for this large-scale event. The matters that we discussed yesterday, today, are very relevant for not only Ukraine, for any country, and for any anti-monopoly authorities. As far as Kazakhstan anti-monopoly law is concerned, during the last years, the number of amendments were made to change the concept of the work of the anti-monopoly service to bring it in compliance with the OECD standards. Let me talk briefly about the cartels and interaction with law enforcement. As you know, the peculiarity of a cartel consists in the fact that it is absolutely prohibited, because the presumption is that in any case this kind of the deal is dangerous for the fair competition. At this point of time, we already have adopted two amendments, or two packages of amendments to the anti-monopoly legislation. It was 2015-16. In 2018, we intend to make the provisions even more restrictive. First, we can do the search early in the morning, for instance, without previous warning. Second amendment is that the potential competitors are now excluded from the definition of a cartel. The third amendment deals not only with the notion, but actually with it's a new definition of the vector of development of anti-monopoly regulation of the cartels. Now it's not anymore about protecting consumers' rights. Rights. We excluded the provision by which cartel is a violation of consumers' rights. So actually, we used to deal with the price-based cartel, the market allocations, boycott, etc. Similarly to many countries, we have a number of penalties, like penalty, for instance, a seizure of proceeds obtained as a result of monopoly, and actually it may be up to 10% of the turnover of the company. Like in Romania and the United States, our officers have the right to enter the premises of the business. We have access to informational system, any IT equipment. We are allowed to make copies. We can demand information from the managers, officials, other employees, including written and oral statements to be made by them. We can also involve experts from other public authorities for purposes of investigation. I'd like to say that the interaction with the law enforcement in our country is also an important area of our work. So the law enforcement officers can actually be present during our joint activities for purposes of investigation, and also in order to prevent any resistance from the suspect. They help us with establishing the location of the perpetrator, and also with convoying him or her to the respective premises. If the proceedings have the penal of criminal nature, then the law enforcement would start preliminary investigation based on our materials. They also provide us technical, practical assistance in securing and recording the evidence. As I said, we draft new legislation in order to strengthen the fight against pricing plots. Price-based conspiracies. Thank you for your attention. And our last participant, last speaker, Ebru İnci from Turkey.
Thank you. I would like to begin by thanking CDF and AMC for this successful organization. It's a great pleasure for me to be here and to make this presentation in front of this distinguished audience. My name is Ebru İnci. I am a competition expert at Turkish Competition Authority. And here is the outline for my presentation. I will first start with giving brief information about Turkish Competition Authority and Competition Act. Then I will move on to TCA's investigatory powers. Finally, I will briefly mention steps that have been taken so far and to be taken in the near future for the enhancements of these powers. As for Turkish Competition Authority, TCA was established in 1997 and is charged with the enforcement of Competition Act. The decision-making body of the authority is the Turkish Competition Board, which comprised of 7 members, including the chairman and deputy chairman. TCA has a public legal personality and enjoys administrative and financial autonomy while while carrying out its duties. And the board is entitled to issue administrative fines for infringements of the Competition Act. The final decisions of the board are subject to judicial review either on material or procedural aspects. Till August 2012, we only had the High Court as the Council of State, a specific circuit within the Council of State with expertise in competition law and economics was reviewing our decisions, uphold them or annul them. But with the law amendment in 2012, it turns into a 2-tier structure, whereas the administrative courts become the first instance and Council of State stay as the last instance court. And since 2016, we now have a 3-tier structure where Court of Appeals appeared as an intermediate stage court in between those two. For the Competition Act, this is the Act number 4054 on the protection of competition, and it covers mainly anti-competitive agreements, either horizontal or vertical, abuse of dominance and merger control. It applies to all sectors of the economy. We only have one exception. It is written in the Banking Act, actually, and it considers mergers with less than 20% of the assets of the sector, and it applies to only acquisitions and mergers between domestic banks. We do have also exemption provisions and related regulations in Turkey. All undertakings, either private or public, are subject to Competition Act. And as these main characteristics that I have mentioned so far reveal, the law and regulations in competition area are in line with EU competition law and legislation to a great extent. As a last point for the Competition Act, we do not have unfair competition or consumer protection areas covered. These are the subjects of different laws and acts in Turkey. Yeah. I can move on to the TCA's investigatory powers, and I would like to start with on-the-spot inspection because I think it is the strongest one. It is the subject of Article 15 of the Competition Act, and it gives power to search of business premises only. We search books, records, documents, and computers and get hard copy of them. We also, during these inspections, conduct interviews in the term of questioning. Actually, we ask questions and obtain explanations from the company officials. Of course, during this process, the rights against self-incrimination and legal professional privilege are highly respected. According to Act, these on-the-spot inspections can only be carried out by competition experts. And it is not a default investigatory tool actually. It is decided by the board up to the case requirement. They are like down rates in Turkey. I mean, they are unannounced and often synchronized. As a main characteristic, we do not need court warrant for these inspections. The authorization certificate provided by the board is deemed sufficient. We have an exception here as well. We usually obtain court warrant in case of opposition or high probability of opposition, and if this is the case, we often have police assistance. The police do not take part in the search, but rather they safeguard the process when we are in the building. The Act sets penalties for hindering and complicating inspections, and it is considerable, I think. 0.5% of the annual turnover initially, and 0.05% for each day as hindering continues. As a recent case, TTNet is a telecommunication company in Turkey, was fined approximately 4 million euros for hindering the inspections. The second tool is information request, and it is the subject of Article 14 of the Competition Act. They are requests to an addressee, either individual or undertaking, to provide all necessary information and documents regarding the case. The addressees can be, well, public authorities, and it can be said as a default investigation tool that's frequently used, either in anti-competitive conduct cases, I mean in cartels or in abuse of dominance cases, either at preliminary inquiry or investigation stages, and also in merger cases, either in phase 1 or phase 2 reviews. The addressee should respond to this information request and should respond within a specified time limit. There is also penalties to failure for comply or providing incorrect or misleading information here. We can also conduct interviews, but they are not like questioning. We make appointments with the officials and we try to understand the case actually there. Here, we do respect also rights against self-incrimination and legal professional privilege, as in the case of the on-the-spot inspections. Leniency in Turkey is not a provision in the Act, but rather the framework was set by a regulation, secondary regulation. As we all know, this is a program for destabilizing cartels, and it's also an investigatory power because it aimed at obtaining information from applicants who participated in the cartel in the first place. The leniency in Turkey offers full immunity. I mean, the first applicant who reveals the cartel to the authority with the adequate information is eligible for this, and also partial immunity in the form of fine reductions up to 50%. We do not have value-added information requirement to be eligible to the partial immunity, but the board has discretion over whether the undertaking meets the degree of cooperation needed. And as the last topic, the steps that have been taken and are planned to be taken in the near future to enhance these powers, they can be classified into three, as capacity building, draft law enhancements, and cooperation with other agencies. As regards to capacity building, TCA began to recruit IT competition experts since 2013. As I mentioned, the on-the-spot inspections can only be utilized via competition experts to overcome this requirement, and with the rise of the importance of the online information, TCA find it beneficial to hire IT competition experts. There is also TCA also set up a special unit for on-the-spot inspection and leniency for coherent and unified approach in those steps. I mean, the investigation teams or inspections team can get assistance directly from the special unit. So we have a unified approach here. We also have in-house training of competition experts on IT search, and also in-house training of competition experts on the essentials of on-the-spot inspections. These trainings are usually concerned with the right issues, actually, how we should behave type of training are given. We have a draft law, and with draft law, the scope of investigatory powers will be clarified. I mean, the current provision either are on spot inspection or information requires are general. So they are not specific or specified. With this draft law provision, we will be able to image data from the company's hard drive, which we currently do not. And we will have the right to seal the offices or cabinets up to 24 hours for later inspection. And also the provision contains the assistance of other personnel in on-the-spot investigation of the business premises. With regards to cooperation with other agencies, we organized seminars and workshops for administrative and court of appeals judges to catch up with the adequate level of expertise after judicial review of structure changes in 2012 and 2016. And we also, as a last point, have protocols, memorandum of cooperation with other public authorities on the basis of information exchange and Public Procurement Authority, Energy Market Regulation Authority, Information and Communication Technologies Authority, and as well the Banking Regulatory Authority are the ones that we have this type of cooperation. Thank you for your attention.
Дуже дякую за цікаві доповіді.
Thanks a lot for very interesting contributions. Before we get any questions from the audience, let me ask you one question. I'm a practicing lawyer in Ukraine, so my interest goes to professional privilege. When you do investigations or inspections, you knock on the door, either alone or in the company of law enforcement, and there are some documents that are entitled to professional privilege. So how do you go about that?
We have legal privilege as part of the law, so we have to respect that. In Romania, we interpret that to mean that covers only document prepared by outside lawyers. So inside lawyers are not covered by legal privilege. Outside lawyers are. If there is any conflict between our investigating team and the lawyers of the company, then the document is sealed. Goes in a sealed envelope and will go to the judge to decide if that specific document is covered by legal privilege or not.
Дуже дякую. Прошу.
На цей документ поширюються гарантії професійних привілеїв чи ні?
We seize documents on the premises of a company or an individual, we automatically at the Department of Justice set up what's called a taint procedure to make sure that we filter out any documents that are privileged. Typically we'll work with counsel for the company or for the individuals on the procedure so that we don't get privileged documents. And if something somehow slips through the screen, it's our responsibility as lawyers to actually alert counsel for the company or the individuals. And that's actually really important to us. It's an ethical obligation. And it also goes to our integrity and to the integrity of our agency. So it's a different story. If someone produces documents to us voluntarily, that gets into sort of more complicated privilege issues that we probably don't want to lay on everybody in the audience. There are some other privileges besides attorney-client privilege, and again, that's sort of a level of complication that it's interesting, but maybe you and I could talk about that afterwards.
Right. And in US, for instance, if I can ask, would attorney privilege only concern outside counsel or also internal counsel, so internal company counsels, communication?
I can't believe I can't quickly answer this question. I think it includes inside counsel as well.
Inside counsel
Stefan
as
is
well.
nodding his head like I think you know. No, I think it does include inside counsel. That comes up so rarely in our cases that it's not something that I'm 100% confident about.
I think if they're providing legal advice, it is covered off. Але я одну річ хочу
One
I won't make you guys put on your headphones, although you speak English, is in Canada, we are seeing a very big difference, Alexander alluded to this, between facing counsel who is trained in competition law and those that are actually criminal lawyers. So competition lawyers who work in the criminal sphere versus pure criminal lawyers. We're seeing more criminal lawyers starting to work in the area of competition law. What does this mean? These people are used to defending rapists, murderers, drug dealers, and they are ruthless to be acting against. These people will look for any loopholes, any sort of things that may come up in investigation. They will attack investigators. They'll attack cases whenever they can. And legal privilege is one of the places they look for in that. And it's not unusual for us to have in our investigations a whole filing cabinet declared legal privilege in an attempt to delay investigations or other things along those lines. And one thing we haven't talked about, and we can if we have time, is that the challenges when it comes to the intellectual technology, the IT, and getting through that information. Legal cases now tend to take a very, very long time. Courts are looking at this very, very negatively. So the challenge from an investigative perspective is to get through things as quickly as you can. But imagine what you get when you pick up a server from a huge corporation. And getting through that information and finding the right evidence that you need can be incredibly challenging. But we can talk about that later.
Дуже дякую.
мука.
Basically, I have two questions. One question is about the topic which was briefly touched yesterday. It's about separation of adjudication and investigation. So all the commissions, so the competition authorities are organized in a way that there is a decision-making panel of commissioners, and there is staff which is doing investigations, and there are different models with regard to interaction between commission members and the staff. So my question is, across different jurisdictions, what is the extent to which a commissioner is involved in the conduction or managing of a particular investigation? This is question number one. No, I will ask the second question then afterwards, because it's a very broad topic. Українською, ну, переклад, я думаю, всі отримали. Мова йде про те, яким чином здійснюється взаємодія
Asking on the interaction between the commissioners and investigative personnel of the entire competition authority in order to see to it that investigation and decision making is separated, whereas it is within the same
field, and I hope I won't committing any mistake by faithfully and truthfully answering it. We just appointed, we have 7 in the board, we just appointed 3 new people. So we're reviewing this issue right now, because this was raised 2 weeks ago in our board meeting. Especially that one of the new board members used to be a member 15 years ago, and at the time he was used to be a sort of super director. Yeah, so each division, a board member was responsible for a division. Yeah, so they're somehow used to talk about cases. Yeah. Since then, we changed our culture very much under World Bank influence. So now it should be, the philosophy should be a very clear separation. Maybe too clear separation between the staff, which is under a director general, the new position, a chief of staff, the director general, and the board. I'm still a bit of a linchpin between the two, yeah, because I see the investigation reports before the rest of the board, because I decide what goes to the board. So in this sense, I'm still in between the two worlds, but theoretically the board should be like sort of judges and the staff should do the investigations. This obviously has some shortcomings, like the staff is going to work for 2 years on a case or 3 years and then it comes to the board and the board says it's rubbish. So we have to find a way. Now we thought there are some moments when the board gets, first of all, the board decides to open the investigation. So somehow the board is having a view if that there is some evidence that's worth looking into it. Yeah. So then the board has to approve the investigation plan. The investigation plan ideally, not always, but ideally should have a theory of harm. The investigation team should say what they try to prove and how they try to prove it. Yeah. So these would be two opportunities for the board, maybe early on, to tell the investigation team, I think you're on the wrong track. We don't agree with your theory. You want to prove something which we believe it's meaningless, does not mean that the law has been breached. Yeah. So that's, I think, the way we'll go. Yeah. So there should be some involvement early on in the board to tell the investigation team if we believe there is a case and what kind of evidence would be persuasive to us. But otherwise, the board should not get involved on which company is asked to provide what kind of information, and we won't be involved to tell the investigation team which conclusion they should draw, because I think in Romanian current climate, this might be the way to prison. Thank you.
Maybe I can answer. For Turkey, initially a board member was charged with the supervision of the investigation. I mean, he or she was placed in the investigation team. But nowadays we do also have a clear separation. I mean, they are not involved in the investigation process at all. So, thank you.
And Stefan, in Canada,
Нас в Канаді так само, як в З'єднаних Штатах, що ми
Like in US, we have to go to court. When we were doing our anti-monopoly committee review, version 1, we looked at this matter, but later on we removed it from the report because OECD cannot tell organizations how they should structure themselves. Because, after all, there are different models available, but Yuri, you were right when you said that there should be some separation between investigation and decision-making within the organization.
But there is no suggestion as to how to do it because 133 jurisdictions around the world and everybody's a little bit different in the way that they're structured.
Які ми досліджували.
Second question is about interaction between competition authorities and law enforcement agencies. So we may just have one form of sort of loose interaction where basically we are all friends, we are all part of state bodies, and we can talk and we can inform each other about whatever interesting incidents we deem appropriate to inform each other. But when, for instance, we see that some authorities, for example, they may listen to the telephone conversations. They may, for example, enter premises, or they have right also to conduct so-called operative activities. So, for example, to not only investigation like in competition cases, but also, for example, to watch some criminal activity in action. What is called оперативная деятельность in Ukrainian, Russian. Is there any practice, positive practice, about conduction of joint investigations, or maybe involvement or some forms of operational cooperation, so to say, for particular in the course of particular investigation, when, for example, one authority, like competition authority, is leading the case, and then there is some form of involvement of either security service or police or, I don't know, anti-corruption bureau or any other law enforcement agency to execute some activity to help the investigation. Because normally classical law enforcement agencies, they act within very rigidly prescribed boundaries. So if they do something, they either, for example, collect evidence because they have signal of criminal activity which falls under the in the competence, or they have a case and then they take really legally prescribed actions, but normally they are very much limited in the actions which they can take. So basically, is there any model in your jurisdiction with regard to really maybe joint investigations or getting really practical operational help from law enforcement bodies to the competition authority?
Thank you very much for this question. I suppose that in some jurisdictions, actually, the law enforcement agencies are the main to search for documents, and then they transfer actually the information to the antitrust divisions. But I will actually pass the floor to the specialist. Thank you.
We have a little bit of an unusual sort of dual system when it comes to those relationships. The FBI is another division of the Department of Justice. So in some ways, one could say, you know, they act as our agents because they have to, although it's more than that. And we have a dual system with the FBI in the sense that sometimes the FBI works up a case and brings it to the lawyers, and sometimes we go to the FBI and ask for help. And so I think that is maybe not so instructive for the situation here. But we also work with other agencies. So if a case involves road building, for example, we might actually want not the FBI, but the expertise of the agents who work for the Department of Transportation. And it's less, there's less formal of a structure than you would think. The way we often pitch it is, one, this is an area that involves your expertise. Two, you will get credit if we bring a case, and credit is good for you. It reflects well on your agency, and good things happen when you get credit. And three, we try to argue that our cases are fun, because sometimes that's really all we have to get people to work with us. We can't make them do it at the end of the day, but we find that making them into our partners is sort of the best that we can do, and we typically get very good results from that. But it may be also that our structure is a little bit different. These are agencies who cannot bring cases on their own. So all they can do is refer cases to the equivalent of a sort of National Prosecutor Service, which is what I do. So I'm not sure how helpful that is, but I hope it makes you feel a little bit better that there's sort of no one way to compel an agency to work with you.
If I can speak from our experience in Canada, as we're partners, I'm responsible in our office for several memorandums of understanding that we signed with fellow law enforcement agencies, both the provincial, territorial police, and the national police, which allow us to do certain things together, most importantly, share information, which sometimes isn't allowed. If we gather information under our act, you can't just pass it over to other parties and vice versa. But none of that is possible without trusting one another, and that's built on relationships, which are built over time. Because let's be honest, when it comes to law enforcement agencies, these are people that we are all A-type personalities that work in this area. We don't like to lose. My boss always says we're not in the making friends business. Nobody goes into criminal cartel enforcement agencies to make friends. Every case you open, it is a contentious issue. There's a war that's starting against another side. And every police agency wants to win their own, so there's egos involved. And there's mandates, and there's budgets, and etc. And you can only get over those things if there's trust and there's working together. How do we get over those things? We have regular meetings with each other. We have joint training sessions. We get together for beer. and we talk to one another about learned experiences. And it's only when we get to that stage that you feel comfortable enough to be able to pick up a phone and talk to other people. That's on a domestic level, and it also applies on an international level. On a regular basis, we do that with the US DOJ and with other agencies as well. But internationally, it's less of a contentious issue because we're usually going after the same people, and we have our own piece of flesh that we want to get. But in Canada, for example, if we're doing an anti-corruption case and I have a competition aspect, they're going for something else, well, who gets to put them in jail? Under what act are they charged? Who gets to stand on the podium when you're putting in the charges? Those are all things you have to discuss, and at the end of the day, make sure that you trust each other and you have that it only happens with communication and discussions. But you have to have the formal mechanism in place, memorandums of understanding, which we recommend in the recommendations for the AMC, formalizing those relationships and then actually actioning them afterwards.
Дуже дякую. Можливо, є запитання?
Thank you. Will there be any questions? Yes.
As we do have memorandum of cooperations with the other regulatory agencies in Turkey, but we do not have joint investigations. The protocols are usually based on the information exchange, and these informations are rather non-confidential type of it. And for the second question, I'm not a lawyer, but I need to mention it first. But there is a clear rule. If you come across a document that is a clear infringement of a law, especially a criminal one, we need to inform the prosecutors about it. That's it. Thank you.
Thank you. Будь ласка.
Кримінальну діяльність ми маємо повідомити поліцію про це. Сергій Щербин, Institute of Economics and Forecasting, Fulbright Scholar, Wisconsin University. У мене запитання до...
As Stefan told, there is a lack of trust of the employees of the companies and managers of the companies to give the proof of cartel agreements to the anti-monopoly authorities and other judicial powers. And I ask you because you are doing technical assistance here and probably may help us. What would you recommend so people wouldn't be frightened to the death to inform the authorities about the crimes? I'm sure that most of the people don't want to be in the crime groups, but what would they choose, to be dead or to be true? And how did you solve this problem in the United States? Thank you.
Very difficult question to answer. And of course, we have a very significant, I don't know if cultural difference is the word, we have a very significant difference in our histories, which makes that situation something we haven't run across in many, many years. I think the fact that we are in a criminal scheme helps. Somewhat. I mean, I don't think that people fear that if they provide information to us that the ultimate penalty is loss of life. I think they worry about getting fired and all the things that happen when they get fired. But because we have a criminal scheme, they worry more about going to jail. So while people do lie to us, they don't lie that often, we hope, and they provide documents because the penalty for not providing documents is not jail, but still there's a penalty. I think individual liability helps because in a scheme like, in a regulatory scheme like there is here, with no individual liability, then, you know, of course, if I had to choose between life and telling the authorities, I'd probably go with life. So while I have a lot of experience doing these kinds of cases, I am not sure that our experience in the United States is as a helpful example. I don't know if any of my colleagues may be able to contribute something else to that.
I wanted to add, there's two quick solutions. We do not recommend them. We just need to say that they need to be addressed, but two that come to mind immediately. Number one is complete confidentiality in the whistleblower status. So guarantee that you will never have your identity disclosed. That could provide discomfort to people. And that is an option. It's provided in some jurisdiction. The other thing that I just came to mind when you were asking your question is something that the Securities Exchange Commission actually did with their whistleblowing program, which is paying whistleblowers. In the United States, the Securities Exchange Commission, you get a percentage of the penalty that the Securities Exchange Commission imposes ultimately on the party. We're talking about tens of millions of dollars in situations. Подумайте собі, 10 мільйонів гривень, якщо ви скажете, що там щось відбувається.
And hryvnias you get for blowing the whistle. Let's ask.
And a lot of these questions are connected to one another because as Alexandra said, if there aren't penalties, significant penalties, people aren't going to submit it. If they're worried about their safety and health, they're going to not come forward. If they're not going to think it's a big deal that the Anti-Monopoly Committee is going to do anything, they're not going to come forward. This is a wholesale change that has to happen in this area on the Anti-Monopoly Committee's watch, and it's a difficult area. I hope you guys support them, both as the government, as citizens, as taxpayers, because it's a difficult transition that has to happen, and it's only to the benefit of everybody in Ukraine for it to occur.
Thank you very much. I have, будь ласка, Олександр Іванович.
Thank you for yet another opportunity to say a couple of words. Going back to my experience with the AMCU, I have something to share in this regard. I'm talking about cooperation between Anti-Monopoly Committee of Ukraine and law enforcement agencies. That cooperation may only be successful if it's based in a law. If the law somehow provides that these agencies have to cooperate, you may expect some tangible results. Well, back in 1995, we made a memorandum of understanding and agreement with the Prosecutor General's office, under which we did information exchange, invited them to various meetings we did, and since that time, we saw that there were a couple of guys in PGO who knew what we were talking about. Speaking of the Ministry of Interior, no cooperation whatsoever at that time. Why? Because there were no statutes, so to speak, that provided for such cooperation. Even now, those memorandums of understanding may only enable information exchange, but only because it's in the law on the Anti-Monopoly Committee. For the Anti-Monopoly Committee of Ukraine, it's a stranger's observation. The new anti-corruption authorities established recently in Ukraine provide new opportunities for cooperation. I hope that we could use this opportunity to legislate on liability of individuals, physical persons, so that the Anti-Monopoly Committee could investigate them. Yeah, I think that we can find a new model underpinning cooperation between the Anti-Monopoly Committee and the classical law enforcement agencies. And one other thing, we are in the judicial reform. We worked with courts for many years, joint meetings, conferences, study visits, training events here in Ukraine. The system worked fairly well, without a hitch, and many judges at that time were well familiar with competition rules. So there is a chance now to enhance that experience. What's actually on our agenda now is another coffee break, but allow me to cut into it as my question relates to investigations, to completeness of investigations and implications. Now, investigation is complete. Findings are shown in the statement of objections or some other submission. Then the commissioners look at it at their board meeting. And your jurisdictions, can the Board of Commissioners just support the findings of investigations or dismiss some of those findings, reject them, and what happens then? Do they return the case for supplementary, so to speak, investigation, or dismiss it wholesale? So what are the options for the board making decision on the findings of an investigation? Thank you. У нас справді 5 хвилин, тож спробуйте лаконічно.
These three options. It's normally if the team wants to send proposes the company should be sanctioned, then it has to be a hearing. The company is informed, they come with lawyers. And we have three options. Either we accept the report and we fine the company, or we dismiss the report, we say they are not guilty, or we send it back for revision. So all three. I looked at some statistic. I think in 90% of cases we agree with the team.
Maybe I can answer that. The duration of the investigations are defined in the law, and it is 6 months for Turkey. And after the hearing, it's the right provided to undertakings. Then the board needs to decide and can decide in favor of the investigation team, and also can decide in favor of the parties as well. So has absolute discretion there. That's it.
Thank you. Thank you. I think we can actually talk without the end on those very important topics for Ukraine and for other jurisdictions. I want to thank all of our presenters today for very insightful and very, very thorough presentations. So let me applaud. Let us applaud the presenters. And special thank you for the organizers of this wonderful forum, and we hope that this will be a tradition on an annual basis at least. Thank you.